I'm pleased to introduce Gord Meiklejohn, and if you have been following the importance of the stock option cases in terms during the period of reasonable notice, you'll no doubt have read the Victor Veer case, and John was counsel both at the trial and at the appellate level. It's a very important decision because it takes a serious run at Brock, and Gord's real fame is that he's married to Gina Brannon, who you may have been hearing on CBC every Monday over the last few months, or the last month and a half, talking about the election and the activities in Shawinigan. Gord?
Thanks, Mary. I won't talk about politics because I'm a Tory, so there's not much to talk about. But I'll talk about stock options.
You're up 1%.
Yeah, good, wonderful. I've provided a paper, it's in your materials, where I've set out the issues as I perceive them to be in dealing with stock options during the period of reasonable notice. And I've referred to some of the cases that I'm aware of that touch upon the issue. And the answer is, as I see it, based on a combination of the language in the agreement and the evidence that comes forward at trial. Now, what I propose to do is talk today about my knowledge of the area that I derived from acting for Victor Veer against Dover Corporation, and use that as a background for you as to how that case evolved both at trial and in the Court of Appeal on the issue. Victor Veer had been employed with Dover for some 47 years, was a senior executive, 62 years of age, when they said you're terminated for cause. And basically the cause existed of his traveling to Hong Kong when the president, his immediate superior, Victor was a vice president, had told him not to go to a closing of a joint venture agreement. Victor thought it was in the best interest of the company and the joint venture partners that he be there. He went, president caught up to him, suspended him, a month or so later fired him. We sued. A large part of his remuneration were stock options. Let me deal with the cause first, and then we'll come back to the stock options. For difficulties getting on the trial list and death of a brother, et cetera, the case was delayed a bit, and that was fortunate for Victor. Two pretrial judges had offered the opinion that the company had cause to terminate him, and therefore he'd get nothing. At the time of termination, the company had offered him a year's base salary to settle the matter. He refused. As a result of the delays, out came the decision of Justice Epstein in Ditchburn, which helped immensely. And actually during the trial, the Court of Appeal ruled on it, Justice Gouge upholding the decision. That caused Justice Lax to find that while he'd been guilty of misconduct and insubordination in going to Hong Kong, given all the circumstances, and specifically his long tenure, his senior position, that it wasn't appropriate to terminate him, and the company should have looked at other ways in which to penalize him for that misconduct. So she ruled that he had been wrongfully terminated, awarded him 2 years' notice, and then turned her mind to the question of what damages flowed as a result, one of which were the stock options. Now, the evidence, as it came out at trial, and I offer the comment that the defense didn't pay a lot of attention to the evidence involving the stock options. And I think that was because of the two pretrial judges' comments that they had cause to terminate Victor. So their focus was on cause, and all of their time spent at trial was basically on the cause issue. Even with the decision in Ditchburn, they still focused on cause. So basically his evidence on the stock options went totally unchallenged. And his evidence was that he took advantage of every stock option that came along. He purchased the stock, and except for one occasion when he sold stock and received a letter of reprimand from the New York head office of Dover, he hung on to all of the stock, so that at the date of his termination, he owned most of the Dover stock. Now, this area wasn't explored by defense counsel on his discovery. If it had been, he would have discovered that Victor, upon ceasing to be an employee with Dover, divested himself of a great deal of his Dover stock. That was based on the advice of a financial advisor. And so that come trial, he didn't have anywhere near the Dover stock that he had. There was maybe 10, 20% of it left. Now, I'm aware that if the argument was he divested himself of it in order to feed his wife and his kids, well then I don't have much of a concern. But that wasn't what happened at all. He didn't need the money. He simply bought other stock, which information I think would have swayed Justice Lax perhaps the other way and found that she would value the loss of the option at an earlier point in time. So what she ultimately did was value the options as at the date of trial, which by that time they'd gone up significantly. I think the number was some $680,000 was the option damage portion of $1.1 million or so in total damages. So the value of the stock options was a huge factor in her award at the end of the day. As I say, there was very little evidence in response on both the question of entitlement and on the question of the valuation. The arguments that we did have before Justice Lax on the issue focused upon the language of the stock option agreement. In the Veer case, it's in my paper at page 5 of the paper, and the two previous points on determining the language in the stock option arose in Justice Griffith's decision in McDonald and Lack Mineral, and a case involving Brock and the Matthews Group. What Justice Griffiths did, and the language in that stock option agreement is also in my paper at page 2, the specific language. That option agreement simply specified that with the termination of the individual's employment, the stock options also terminated. And Justice Griffiths held that with that language, you read in the word lawful, so that with the lawful termination of the employee's employment, the stock options terminate. And then that takes you to the end of any period of reasonable notice in assessing the damage. So in the case of McDonald, Justice Griffiths awarded the loss that arose from the stock options that he would have received a year or so, or within the year of his termination. I think he gave him 12 months notice as reasonable notice. So he incorporated the loss from the following year and included that in his damage claim. Now, the other case that Justice Lax was asked to follow was the Brock and Matthews case. Now, Justice Griffith's decision was a couple of years before Brock and Matthews, and I suppose somebody acting for the Matthews Group read it and concluded, well, if we put this language in, and basically what they put in was language that caused the stock options to be terminated at the date notice of termination was given. So the focus then becomes not termination, which you read in lawful, but the day you hand the employee the letter that they're terminated. Now, whether that's with notice at some point in the future or unlawfully terminated, and a court concludes that it was not effective until some point in the future, the operative language focused on notice. Now, the Court of Appeal didn't really state it quite as clearly as I just did. A lot of the judges have interpreted as that is what it means. So my advice to anybody drafting a stock option agreement for an employer who wants it to terminate at the time notice is given to the employee is to get a copy of Brock, get a copy of the stock option agreement in Brock and Matthews, and follow that. Because as far as I can see, every other company that's tried to terminate the stock options sooner than the end of the notice period has not met with any success, despite some language that I would have thought would have been successful. British Columbia cases particularly that are referred to in my paper. One would have thought with that type of language in the stock option agreement, you would have been successful bringing it to a close earlier. They haven't been. So, and there may be cases that I'm ignorant of, but as far as I'm aware, Brock and Matthews is the case that has stood the review. And the trial judge, I think it was Justice O'Leary, held that the Griffiths reasoning should have been imported into it and should have been applied, whereas the Court of Appeal overturned them and said, no, the operative date is the date notice was given. Now, in dealing with the question of valuing the stock options and the point of time, when we argued before Justice Lax, the only authority I could find, and I think it was the trial decision in Ryan and Laidlaw, that held the point in time to value the loss was at the end of the notice period. That did some good in the Veer case, but I think it was probably only about $150,000 that they'd increased by that point in time. So the substantial damage claim came during the wait for trial, and that didn't help us greatly. I believe the reason Justice Lax ordered it or assessed it at the time of trial, twofold. We had an expert who continually updated the report as the stock increased in value. So at the various pre-trials, we'd present a report that valued it as at that point in time for settlement discussion purposes. And then prior to trial, we presented the evidence that valued it a week or so before the trial date. Justice Lax reserved for a period of time. We then had argument in respect to further submissions. So the stock even gone up even further by the time she made her ruling. But I think that was a factor that the expert's report was there. It was unchallenged, as well as the evidence that I've just mentioned earlier about what Victor had actually done with the stock options. I was greatly concerned with it going to the Court of Appeal. 2 points were raised in the Court of Appeal. Failure to mitigate. Marty Sklazizzi suggested that Victor should have gone out in the marketplace when he was terminated. Justice Gouge looked at him and said with what money he was terminated. And then secondly, the argument in respect to it shouldn't have been valued at the date of trial, but at the date of termination. And I was greatly concerned because, again, I hadn't found any evidence other than your standard rule of thumb in assessing damages, what is reasonable, to support the position that Justice Lax took. And I was greatly relieved in response to Mr. Sklazizzi's argument on that point. Mr. Justice Laskin looked at him and said, so what? That was the end of that argument. So that, I think, simply tells us that the assessment of damages is very much within the scope and realm of the trial judge. If you can put together evidence, call evidence that it seems reasonable what the approach is that you're asking the court to take, you likely will succeed on that score, and the Court of Appeal won't interfere with it. So in summary, the most important area in stock options is the language of the stock option agreement, and then the facts as they may present themselves that allow the court to reach a decision as to what is reasonable. Just before I leave, I think my time's almost up. In Dover, the head office of the company was in New York City, and I think Justice Lax took some comfort in the fact that in dealing with the stock options, the actual person before her wasn't the company rendering the stock options. This was a dispute between the president and the vice president, and head office was far, far removed. So for her to conclude that the head office should be paying a large, large amount of money, I detect that she didn't feel like she was penalizing somebody that was there involved in this actual lawsuit, that it was somewhat of a long-distance payer, and therefore it wasn't seriously contested that he was entitled to a substantial amount of money in that regard. There are then jurisdictional questions that may come into play on that, but that may be for another day in another case when we'll find out something about that. Thank you.
Thanks very much. A very complex area, and depending upon the stock market, things aren't so good right now, but you know, I've got a case on the go, fairly complex. The stock was issued at US $7. It was trading at the height of the summer at 125. Yeah. That sort of leaves a lot of room for maneuvering, especially with US companies who think they can just look at our employees and say, well, you're terminated, the stock option plan terminates, it was nice to know you. In cases like that, you know, the damage claims in that particular one is going to be well over $2 million. So stock options is going to be perhaps far more important, depending upon the market, than reasonable notice in evaluating that. Our next speaker is going to look at damages, some punitive, some mental distress, see what's happening down from Windsor, up from Windsor, I suppose, and it's a little bit warmer down there. Marginally. Anyways, it's our pleasure to welcome Ms. Marcotte, and she spends a lot of her time dealing with the employment issues in the Windsor area.
Thank you very much for your comments and good morning. I have an admission before I begin my presentation. Hopefully you've received my paper. It should appear roughly at tab 19. You'll note from my biography that my practice is limited principally to representing employers. So while my initial attempt in terms of this paper was to provide an objective point of view, I don't believe I succeeded. I'm going to have to take a few water breaks during the presentation. I've been fighting the flu and a cold for the last 2 weeks. I propose to follow the general flow of the paper, but I do warn you that I will go off on a few tangents because some of the issues that interest me in terms of particularly mental distress damages relate to one case that I've actually done before a Canada Labour Code adjudicator, and another case, actually a case from the BC Labour Relations Board that I found particularly interesting. Now, I haven't mentioned them in the paper, but I will go off on a brief tangent right at the end of the section dealing with mental distress. Prior to Wallace, I think everyone had a general understanding of what was required in order to secure an award for damages for mental distress. You had to have an independent, actionable wrong, and you had, as plaintiff counsel, to provide the court with medical evidence in terms of medical documentation and/or a witness to give testimony on that issue. And then Wallace came out. And I refer you to the quotation that most plaintiff counsel will rely upon to support what I would call option B or argument B. And that is an argument to extend the reasonable notice period in the event that the plaintiff is not successful in securing mental distress as a separate head of damages. There are a few sections in this passage that I would like to specifically reference because I think those are the passages or the sections of the quote which has caused particularly defense counsel great concern. In the fourth line of the quote, I note, however, that in circumstances where the manner of dismissal, and I would underline manner of dismissal, and I'll get back to that later, but very briefly, what does that mean? Does that mean that if the allegation of cause is not successful, you're going to be entitled to extend the reasonable notice period? Or does there have to be something more in the manner of dismissal to justify the extension of the reasonable notice period? And then we go on, has caused mental distress. So there has to be some evidence of mental distress in order, even when you argue what I call the argument B or the Wallace factor, but falls short of an independent actionable wrong. The employee is not without recourse. Rather, the trial judge has the discretion, and that's always, something that's unclear, especially when you're trying to provide advice and generally quick advice to an employer who is in a position where they might be proceeding with a termination. In these circumstances, to extend the period of reasonable notice to which an employee is entitled. Thus, although recovery for mental distress as a separate head might not be available, the possibility of recovery still remains. And so we look at some of the cases that might assist us in determining how we go about applying the Wallace factor. And the first case that I looked at was Nagy. This is a March of 1998 Ontario Court of Justice decision. And the quotation, Nagy's claim at page 2 is that as a result of the manner of his termination, and in particular, the allegation of wrongdoing in the nature of fraud and theft, caused him mental distress accompanied by physical and psychological consequences. There was medical evidence in this case that was provided to the trial judge. And you'll note in the first part of the quotation from the trial judge's award, he did not find that there was an independent actionable wrong. So argument A was not successful. However, the trial judge then went to look at what I would call the Wallace factor, or argument B, and said, I have, however, taken his evidence on this point into account in fixing the amount of reasonable notice. But for the evidence of mental distress, I would have been inclined to fix the length of reasonable notice at 15 months, but under the circumstances, I have increased it to 16 months. Now that's only 1 month differential. However, the principle in this case causes defense counsel probably a lot of concern, because this case seems to stand for the proposition that if the employer alleges cause and is not successful at trial, you're going to be faced with the Wallace factor. Now that's not necessarily a principle I hold to. I think there has to be something more than an allegation of cause that does not succeed at trial. There has to be something in addition to that factor that contributes to the conduct of the employer to such an extent that it is deemed to be insensitive, callous, or a mistreatment of the employee. I go on then in the paper to say that I think the courts are tending to move towards this kind of proposition. And I refer specifically to the Schmidt case first. It's an Ontario Court of Appeal decision dated May of 1999. And it's my opinion that this case stands for the proposition that in fact there must be something in addition to simply the allegation of cause that does not succeed to support a Wallace argument. And at page 3, you'll notice the quote out of this particular case. The judge states, however, a review of the record in this case discloses nothing in the manner of the dismissal of the respondent as opposed to the fact of dismissal that would have entitled the trial judge to exercise his discretion and extend the notice period even if he had sought to do so. As the trial judge acknowledged, the respondent was not entitled to a formal hearing before he was discharged. In fact, he was given the opportunity to comment on remarks attributed to him by his fellow employee, and he took advantage of the occasion. Now, in this case, the respondent at the appeal of the trial judge's decision had conceded that there was no independent actionable wrong. And so the respondent was then going into the argument B to support the claim, to support the award of the $15,000 in mental distress damages. In terms of what kind of conduct might be relevant to support a Wallace argument, I had referred earlier to insensitive treatment, mistreatment of the employee, and it could be either prior to the termination, during the termination, or subsequent to the termination. I think we're looking at such things as, public announcements, sending emails out, to other staff members, citing the allegations for cause in the event that those are not found to be In addition, I think that a faulty investigation, or in fact no investigation, might contribute towards a good or successful Wallace argument, and not providing the employee with the opportunity to provide an explanation once you have determined that there might in fact be some conduct, offensive conduct, or misconduct by the employee, perhaps would lead a judge to conclude that the Wallace factor ought to be considered. The last case referred to in this section is the Gaudio case. Now, this was mentioned earlier by a previous presenter, so you've heard the facts already. What I would like to focus on is the claim for mental distress. And the quotation is at page 3 of the article. The central theme in each of the above passages, and he's referring to the passages in Wallace, is that the conduct that is to be compensated for must arise from the manner, again referring to the manner of the dismissal, in which the dismissal is affected by the employer. Here, there is nothing in the manner of dismissal which could give rise to the type of conduct to which Mr. Justice Iacobucci is referring, other than the fact that the defendant relied on an allegation of cause for the termination, which ultimately was found to be unsuccessful. By that, I mean there is nothing in the actions of the defendant over and above the allegation of cause that caused or contributed to any damage to the plaintiff's sense of self-worth of the type Mr. Justice Iacobucci canvasses in the cases mentioned in his reasons. Now, the two other cases that I would like to refer to that do not form part of the paper. The first one deals with the BC Labor Board, a Labor Board decision. It's Tillicum Hoss Society and the BC Nurses Union. It's a decision dated July 2000. Ms. Johnston was a nurse that was terminated one day after the first date of a hearing on a certification application. The employer had alleged that she was terminated for cause. The original board determined that she was terminated for anti-union animus. And in the first instance, the union had argued that she should be compensated for damages for hurt feelings and mental distress. The original board denied the request for damages for this subcategory on the basis that there was no direct link between the termination and the alleged hurt feelings. They did not specifically address the issue of the jurisdiction of the board to award such damages. The union then asked for a reconsideration, and the reconsideration was heard by a different board. Fortunately, speaking on behalf of defense counsel, the second board did specifically address the issue of the jurisdiction of the labor board to determine issues of mental distress. And they found, in fact, that because of the purpose and the nature of the code, the objectives of the code, and the legislative authority within the sections of the code, they did not have jurisdiction. What's interesting about this case is that the BC Nurses Union attempted to rely upon Wallace in support of their argument that the board should award damages for mental distress. And the board that reconsidered the issue clearly came out and said that the Wallace principles apply to the common law, and that where there is a regime to handle collective bargaining or labor relations issues, the Wallace principles ought not to be applied. Now, I haven't seen a similar case in terms of the Ontario Labor Relations Board, but the potential is out there, and so I thought I'd raise it for your consideration. The other case that I'd like to briefly comment on is a decision under the Canada Labour Code dealing with the unjust dismissal section, and that's specifically section 242, section 4, and subsection C. And if you refer to Mr. Sproat's paper and presentation, you'll see that section nicely outlined for you. This was a case that I actually argued in front of adjudicator Springate in May of 1999. And the employees' council argued that the terminated employee ought to be compensated for mental distress, and she also argued punitive damages. Adjudicator Springate determined that he did not have the jurisdiction to make an award for punitive damages. But when we went later on to discuss damages for mental distress, he did in fact find that under section 242, section 4, subsection C, he did have the remedial authority to issue damages for mental distress. And what was of most concern to me at the time when I was arguing the case was that there was no evidence, aside from the terminated employee's testimony, to indicate that in fact there was mental distress. There was no documentation from a medical practitioner, nor was there testimony from a medical practitioner. And in the previous Canada Labour Board decisions, there were 3 that were filed with adjudicator Springate. In all 3 cases, there had been medical documentation to support the claim. In this case, there wasn't. And so I argued that the adjudicator should not be supporting or awarding mental distress damages in this instance. And he obviously didn't agree with me and awarded $5,000 in mental distress. Now, we were seriously considering appealing that decision, but we ultimately got a settlement, so we didn't proceed any further. But I just highlight that for your attention in the event that you're in the federal, within the federal jurisdiction, so that you know what's out there. The other thing, just before I leave that Canada Labour Code decision, although the Wallace decision was not specifically argued in that case, it wouldn't surprise me in the future if more counsel who appear before an adjudicator attempt to rely on that case. Now on to punitive damages. Punitive damages, or an award of punitive damages, has always been based on the finding of an independent, actionable wrong. In addition to complying with that requirement, plaintiff counsel, and I'm going to use the direct words out of the quote from the Whiten case, and that appears at page 4. The conduct must be sufficiently harsh, vindictive, reprehensible, malicious, oppressive, high-handed, that it offends the court's sense of decency. And that's a fairly high burden. Some examples of conduct that will support a claim for punitive damages appear in the list that I've provided at page 5. And I've chosen to, in the paper, comment specifically on the Ben David case because I think it's an interesting case for a number of reasons. First, the trial judge, in his award, clearly identifies in the body of the award that he must find an independent, actionable wrong to support an award of punitive damages. What is absent, however, from the decision is the identification of what that independent, actionable wrong is. He talks about the conduct, but he doesn't talk about the independent, actionable wrong, which would have been helpful, probably to both plaintiff and defense counsel. Having said that, he then goes on and says that, excuse me, that the conduct that the employer participated in this particular case, does meet, I guess, the higher standard or the higher burden of what is considered to be malicious, high-handed, offensive, offending the decency of the court. And there are some examples that are given in the paper to support that conclusion. Now, as I said in the paper, although, I just want to go back to one point because I missed it. Although the trial judge does not specifically identify the actionable wrong, it would appear from the reasons that were adopted in support of punitive damages that he may have, and this is just an assumption on my part, but he may have used the ratio in the Whiten case in terms of an obligation to act in good faith, and any breach would be an independent actionable wrong, to support his conclusion that punitive damages were appropriate in these circumstances. The other important principle in the Ben David case is that not only do you have as defense counsel to be concerned with the conduct of the employer at the point of termination, but you've also got to be concerned with what occurred prior to and what occurs after the termination. Because the time frame, according to this trial judge, covers all of those periods. Oh, jeez. Okay, I have 5 minutes, so I'm going to be real quick. I don't have any dispute with with finding that the conduct in the Ben David case met the standard of offending the decency of the court. The list that I provided to you, I think, gives you a clear indication that the harms inflicted were of a very personal nature and were severe in terms of the circumstances of this particular plaintiff. Advice in terms of defense counsel: the ideal situation is that you have enough time to spend with your client to determine if they have grounds to support an allegation of cause. The ideal situation is one where you have time to spend with your clients to determine what action has been taken up to the point of termination, what their plans are for the termination meeting, and give them some good advice as to what to do and not to do after the termination. That's the ideal, perfect world. The reality is you get a call on Friday at 4 o'clock saying, we want to terminate this person Monday morning. And you generally have a verbal discussion with the HR person or the senior executive, and they verbally tell you, you don't get a chance to see the documentation, you don't get a chance to interview the witnesses that you're going to present at trial, and you have to give advice about whether or not you think there is cause. And to the best of your ability, you do so. I now am in my practice now is to ask questions in addition to the cause issues and what factors that the client has supporting cause, I ask, is there anything else I should know about that might be relevant leading up to the decision to terminate that may cause a judge to be concerned that we have not acted appropriately? I then ask what their plans are for the termination meeting. And if I have an opportunity, I do give them some advice in terms of what action they should be taking following the termination. This is what I suggest. This is what I would advise defense counsel in the event that they have time. But in the real world, it always doesn't happen that way. Thank you very much. I realize I'm out of time. If you have any questions.
We have time for a couple of questions.
Unsupported allegations of theft? It could, yes. Because of the nature of the allegation being theft, which could have some serious consequences on the employment prospects of the terminated employee, yes, I can see that perhaps it would attract punitive damages.
Are you aware of the case law?
No. The two cases that I'm familiar with in terms of punitive damages is the Chalal case that I referenced right in the last section and the Chen case. But both of those cases deal with allegations of cause that directly affect the professional integrity. They were really personal attacks. So they're not quite theft related, but I could see someone potentially successfully arguing that completely unfounded allegations of theft, i.e. concocted allegations of theft, might directly affect the professional integrity of a terminated employee, and such as to attract punitive damages.
There's a case in which someone made a speech giving allegations of cause on the steps of the PI legislature, and the defamation was the independent actionable wrong that gave rise to punitive damages being awarded. I mean, the problem with this is, although a trial judge would want to give punitive damages for unfounded allegations of theft, you'd think that the Wallace case would say you can't unless there's some independent actionable wrong. Now, the Witten case of our Court of Appeal said the breach of a duty of good faith is an independent actionable wrong, but you'd think that Wallace specifically contemplated that and said a breach of that duty is not an independent actionable wrong, and therefore they had to give this other theory of extending the notice period. And they specifically decided that breach of a duty of good faith in and of itself wouldn't be an independent actionable wrong, as I read the Wallace case.
And normally what you find is that where there are cases of maybe high-handed conduct, as opposed to, an independent actionable wrong, something involving defamation, that sort of thing, the courts are pretty good, from my review of the case law, in extending the reasonable notice period, as opposed to awarding punitive damages. I think they've made that distinction fairly clearly.
But that was the whole problem when the argument of bad faith was you wanted to have an independent actionable tort, so there'd be separate damages, but the court didn't go with that argument, ultimately. I mean, they spoke eloquently about bad faith, but they didn't really attribute a number to it.
Or if there's a fixed-term contract, you have the same problem.
Howard, you guys know this. I thought Norman Grosman did a case called Rubiro and CIBC. And didn't Norman act for CIBC? And wasn't the allegation in that case was that the CIBC claimed to the world that Rubiro had
Yes.
engaged in cause?
And he got, yeah.
And it went to trial.
It went to trial, went to the Court of Appeal, and $50,000 was awarded for punitive damages in that. And it was a very unique circumstance because in the Ribeiro decision, they had deliberately, I mean, this was a case where someone had deliberately set this guy up and even had gone to the extent of having him arrested.
Yeah.
And it was still only worth $50,000 in the end.
Now, I would have thought that that case is still good law.
Yes.
Like Waltz.
Absolutely.
So there's a case where punitives were awarded, and actually the usual punitive damages were sort of 10 to 15. So I mean, the Court of Appeal, I remember the Court of Appeal saying, we want to make a fashion statement. So
Right.
we're going to ding you for 50. They thought they were making a statement.
Yeah, and the remarkable part, they thought they were making a statement, but $50,000 for having somebody literally arrested in an entire fabrication. It wasn't sort of an innocent error on the part of the CIBC. Anyways, unfortunately, we do have to move on to David as the next speaker on the privacy issues. We added this into the conference when we had our meeting last week because we thought it was important to put these very important issues on the table and to evoke some discussion on it.
Okay, so we've got 15 minutes to talk about privacy legislation. Sorry.
12 and a half.
I've got 12 and a half minutes to talk about privacy legislation, and if I complain to Barry, it'll be cut down to 10. And so rather than showing my snappy PowerPoint presentation, it'll take me too long to flick the buttons. You guys have the hard copy handout. Why don't we just quickly go through them together? And so let me just give the caveat. This presentation doesn't deal with personal information relating to non-employment situations. So there's a whole part of the legislation that deals with personal information relating to consumers, for example. So if we all own a conference organization and we're in the process of selling customer lists, even though there are no employment issues, this legislation will have a huge impact if for the first little while you're doing it interprovincially, and after 2004 you're even not doing it interprovincially. So this thing doesn't deal with that. It also doesn't deal with the whole electronic documents and signature provisions of the statute. There's no way we'd have time for it, and in any event, those provisions don't really deal so much with employment law. So, okay, the question becomes, what does this presentation deal with? And we see it on the hard copy. The legislation from an employment law perspective deals with the collection, use, and communication and disclosure of what's called personal information by what's called organizations. We need to know what an organization is. We need to know what personal information is. An organization is essentially anything. It even specifically includes a trade union. So it's a company, it's a partnership, it's an association, it's a trade union. In other words, it's an employer. What's personal information? Again, essentially anything about an individual, about physical or mental health issues, health services that are provided, even the donation of bodily parts or substances. So good old Mr. Thompson, when he dropped off his vasectomy sample, you know, if this legislation comes in on Jan 1 and his company is engaged in interprovincial travel, it'll cover his vasectomy sample. What's not included in the definition of personal information? Information that's collected for personal or domestic reasons, information for journalistic reasons, information for artistic or literary reasons, and then there's what's called in the trade a business card exemption. That is your name, title, business address, or telephone number at work of an employee. So if I hand my business card to John Hanna, who turns around and hands it to the person sitting behind him, he doesn't need to worry about complying with data privacy legislation, thank heavens. There are some regulations that have just come out, I want to say within the last week and a half or so. I'm surprised I'm even aware of them. Information contained in telephone directories is exempt from personal information. Professional business directories, information that goes into magazine and newspaper articles, and we'll also know that there's an exemption in the legislation for the exchange of personal information if private investigative bodies are claiming a breach of law. So the regulation also specifically sets out who those private investigation services are. John, it doesn't include Brink. Sorry about that. Okay, So who does the act apply to, and when will it start to apply? Effective January 1, 2000, the statute will apply to organizations. We know an organization means anything. That's a federal work, undertaking, or business. Go back to John Sprout's talk on the Canada Labour Code. It's the same, right? Are you a railway? Are you Atomic Energy Canada? Are you an airline? It's gonna hit federally regulated employers effective Jan 1. Also, it's going to hit provincially regulated employers effective Jan 1 that disclose personal information for consideration, i.e. for a quid pro quo, on an interprovincial or international basis. Again, quick example. Assume we're a conference organization and we sell membership lists to a company in Alberta. So there's the disclosure of personal information interprovincially for consideration effective Jan 1, 2001. The legislation will apply to those types of entities as well. Obviously, conference organizations aren't the only ones that are going to fall within this bailiwick. There'll be a year's grace. That is, it'll come into effect Jan 1, 2002 for organizations that collect, use, or disclose personal health-related information, a defined term in the statute, and all other organizations will be covered effective Jan 1, 2004, unless the province where the organization is resident enacts its own privacy legislation. It's widely anticipated that this will happen. We know the provincial government has a white paper out. I believe BC has draft legislation that's making the rounds. I believe Manitoba has draft legislation that's making the rounds. And so it's only worth a 20-second footnote to at least raise the point whether or not that would be constitutionally valid legislation to purport to apply to provincially regulated employers. I don't really think it's going to matter, because I believe privacy legislation is certainly going up the priority list in most provincial legislatures. Okay, so let's now move on quickly and talk about the basic requirements of the Act. What do you have to do? And what you have to do is based on 10 principles of privacy that are taken from the Canadian Standards Association Model Code. And those 10 principles are attached as a schedule to the actual legislation. Let's very quickly go through the 10 principles of privacy, because my time is ticking away. The 10 of them are, when we see them in the hard copy: consent, identifying purposes, accountability, limiting collection, limiting use, disclosure, and retention, accuracy, safeguards, openness, individual access, and challenging compliance. Let's spend a couple of seconds on each of the 10 principles so that we have some working sense of what's going on. Consent, pretty straightforward. If you're an employer and you're going to collect, use, or disclose personal information, which means anything about your employees, you gotta have consent before you can do that. The consensus right now seems to be that there is not any grandfathering provision in the legislation to give employers a break in connection with personal information that they already have about their employees. And so if you're caught by the Jan 1, 2001 trigger date, by then you are going to have had in your workplace policies and procedures that will comply with the 10 principles, and you're going to have to have obtained consent from your employees, existing employees, to be able to use the information that you currently have. I believe the Privacy Commissioner will take the position that if you don't have that consent, you're going to have to destroy all of your employee personnel files. And so, for example, I do a lot of work for a Schedule II bank, so we're busy little beavers as we're heading up to New Year's Eve. Identifying purposes. This principle stands for the proposition that the employer has to set out to the employees the purposes for which they're collecting the information. You got to do it before you collect it, and you have to think through what you're going to be using this information for. Because if you use it for a different purpose than you told the employees you were going to use it for, you have to get another consent, else you aren't allowed to use it. Principle 3 is accountability. Here's the governing principle. Organizations, i.e. employers, are responsible for personal information that they have under their control. So what do you have to do? First of all, you've got to appoint a designated person within the workplace. It should probably be someone fairly senior, who will be the point person for ensuring that the legislation's complied with and for the initial handling of complaints and queries by employees. You're going to have policies in place that lays out how you get consent, how you store information, how you hand it off to third parties, how you receive and respond to complaints. The policies are going to have training provisions for managers, because you're going to be in trouble if somewhere down the road an employee files a complaint that her privacy provisions or principles have been violated, and the only defense is, oh, the manager didn't really know that there was legislation. That's not going to get you very far. You're also going to have to have safeguards in place to make sure that if you transfer personal information to third parties, you have contracts in place to ensure in turn that those third parties comply with the legislation. Imagine we're an employer and my friend Barry Kuretzky's got a disability problem. He wants to go on actually Barry's had a disability problem for many years, and he wants to go on long-term disability benefits. We have to send information to the group insurer. We have to have in place a contract with the group insurer to make sure that it in turn complies with the principles as well, because if we don't have that contract and they muck up, we're liable. Now the group insurer will be too, but so will we, and we can have damages assessed against us if we don't have those safeguards in place. Limiting collection. The collection of personal information has to be limited to the purposes for which the employees were told in the first place the information was going to be used and collected. And so again, if you want to expand the purposes for which you want to use information, think it through in advance to avoid having to go back for consent. Also, and this is interesting, the information collected has to be reasonable. And so the example in the hard copy is, the Video 99 store you go to and you want to rent a copy of Terminator, or play it did you Play It to the Bone? No? Or play it to Barry and I ran into the video store last Saturday night. We were both looking for movies for our kids. Barry wants to rent a video. And in order to rent the video, he's got to give banking information. He's got to give a social insurance number. He's got to give 15 major credit cards. No, it's across the line. Okay, so there's going to be people looking at you to make sure that the information you're asking for is objectively reasonable. Limiting use, disclosure, and retention. Personal information can't be used, makes sense, for purposes other than which it was collected for. One exemption, if the employee consents, then it's okay. You can only hang on to the information as long as you legally need to. So employers are going to have to be looking at retention issues. How long do you have to hang on to health and safety information? How long do you have to hang on to information that might be helpful to defend against a wrongful dismissal suit? The periods of time are going to be different, so employers are going to need to put their minds to that. Personal information that's no longer relevant will need to be destroyed, and you'll need to have policies in place to make sure that it's destroyed securely. Accuracy, pretty straightforward principle. Barry's giving me the sign. Am I over now?
You're over.
I'm over now. So you can read the rest of the principles. I almost got through all 10 of them. And I don't know if we got time for questions or not, and if we don't, I apologize. I thought it was till 11:35. I've got 11:31. Okay, sorry.
You mentioned on the insurers, the insurance policy turns on a light. I have a client who refuses to authorize, without any limitation, visual and audio surveillance by any legal means according to the thing that they want my client to sign. Would that be an anticipation of this privacy of those ones?
You know what? There's so many facts about that hypothetical that I don't know about. Why don't we do this at the lunch break? Let's spend 2 minutes and we'll work it through, because Barry's a tough taskmaster and he wants to get on to the next speaker. Thanks, guys.
Thanks very much, David, for doing double shift today. The next group of speakers, we have John Hanna from Brinks, Sheila Whaley from Skyjack. Both these individuals I've had the pleasure of working with for innumerable years in dealing with all kinds of human resource issues. As well, we have Janice Rubin and Jeff Simpson, both who have a vast amount of experience in this area of the law. We've come up with 4 questions, and we're going to try to, if the guys will come up to you, we'll hopefully have a dialogue and a panel discussion. And so I'm quite looking forward to this. I'll pose the questions, try not to interfere, and see where the discussion takes us. Just to remind everybody, the Law Society is very grateful if you will fill out the evaluations. It's helpful in planning programming. And we hope that we're going to have a full attendance at the end of the day for the judges panel. You can skip Vassos, Chenoweth, and Sproat if you want, but please be here for the judges panel. It's, the judges give of their time very graciously, and it's important as the bar that we are here at that time. So who's got my questions? Jeffrey's got my questions. All right. Distinguished panel. The first question that we want to look at is how to present an employment agreement looking at the termination provisions, restrictive covenants at the outset of the employment relationship. So we've been hearing a great deal about the legal aspects. We now want to look at sort of on the ground how to actually do it. Who wants to lead off? Sheila.
I think one of the challenges from a human resources perspective is you're in the process of welcoming a new employee to the organization, and then immediately it's, oh, by the way, let's talk about your termination. So it becomes, you know, there's that balance between the necessity of the legal language and the appropriate covenants, at the same time positioning it in a positive way.
John?
Barry, I'll comment if you like. I think it's much more difficult today to have restrictive termination provisions in agreements because the economy is so strong that employees just aren't accepting them. So what you are forced to do as an employer is probably be more generous than you could have been, say, 8 or 10 years ago. And so it's not as big a deal right now because you're being generous up front, because if you're not being generous, the employee won't take the job.
John, what is your experience?
I think one of the, particularly, and a couple of my comments on the other questions will be, particularly when you get into a workplace where the senior managers, if it's a highly organized workplace, they maybe have more experience in litigation previously, and a lot of them will say things like, well, let's just take our chances. And they'll reference cases, well, you know, that case we won, remember the notice that we got, and let's take our chances with either mediation or through litigation, and as opposed to setting a standard up front. Of course, then there's the, you know, trying to identify the dangers associated with that, but sometimes an employer or a senior manager will say, listen, it's important that we get this person on board because, as Jeff was saying, if we don't take this person, the search firm has no one else for us. So let's just move ahead and we'll deal with it later.
Janice?
The comment that I would add is I think that none of this is written in stone. For example, I have a number of employers where market conditions do allow them to have employees sign on to with employment contracts that are just notices limited to the Employment Standards Act. And when it comes time to terminate, for whatever reason, I guess more on a personal reasons, they feel a little bit queasy letting the person go just based on the statutory notice. So at that point in time, we discuss whether they feel it would be appropriate to make what we call a gratuitous payment in addition to what's set out in the contract. So employers have a certain amount of flexibility, notwithstanding what's in the contract, to do more. You probably don't have a lot of flexibility to do less, but certainly you can do a little bit more.
One other comment would just be that I think periodically employment contracts have to be revisited after a period of time, because an arrangement made at the start of employment might have been suitable at that time, but several years down the road, for example, the gratuitous payment piece might have to be revisited in order to make sure that it's still equitable.
Both Sheila and John, on the same light, what we as lawyers don't often have any experience with unless we're sort of hiring at our own firm is what the actual discussions are like with someone when you're presenting a contract to them, and what kind of reaction are you getting from them? What kind of facial expressions, in the sense that, you know, are you guys crazy? You want me to sign on to employment standards? So I'd really like to give the lawyers in the audience sort of the benefit of what we tell you is what's really happening when you're actually out there.
I guess and I've actually had that recently, particularly when you're looking now in the current market at jobs that are paying in the, we'll say 85,000 plus, you know, incentives and whatever. When you have employment rates of somewhere around, I think unemployment rates of 5.6%, which I think it is currently in Toronto, you're closing in on full employment, which is around 4%, according to the statisticians. And the problem that you have is you're sitting there in the search firm, which is getting 30% of the, or 32% of the individual's salary.
And he complains about lawyers' bills.
That's right. To put someone in front of you is saying, listen, you know, you eliminated this person for this reason, this one for that one. You didn't move quick enough on that one. This is it. And you're sitting there and you're looking at them and they're saying, you know, you presented to me, and I had someone say, you presented to me that, you know, you have a work environment which is encourages development, that this is a place where I have real opportunity, you care about work and family balance, but now you're telling me that I have a probationary period, and this is what I'm going to get if anything goes wrong. And you say, so, and the individual said to me, what's your intent here? Like, I don't get a warm, fuzzy feeling from this letter and our discussions with you. Like, I don't want to know that you're gonna fire me within A, the first 6 months, or B, after that, and this is all I get. So I'm not comfortable in signing this, and I want to actually talk to my lawyer. And all of a sudden you're going, oh, they haven't started, and they want to go and see their lawyer. And you go, oh my God, what's going to happen now? And that's where I guess, Barry, one of the points that this came up is to say, so how do we as an HR executive or an HR person, how do you put that in the proper context so that it is, you can soften that? And I don't know, Sheila, if you have any thoughts on that.
Yeah, I would encourage them to go to a lawyer just to make sure that, you know, they're comfortable with what they've got. I think you can always tell who's had an employment contract before and who hasn't. The ones who have don't seem frightened by the restrictive covenants. The ones when it's their first time round, these are things that perhaps are always implicit in previous employment, but now it's being laid out for them in black and white. So that's the sort of the extent of the reactions that I see. I think sitting down, doing the presentation face to face, maybe even asking if this is their first employment contract and giving them a bit of background to take away could help to increase their comfort level.
Do you see a rise of employment contracts, the use of contracts, or do you think it's going to be seriously in decline because of the full employment?
I see it being on the rise, more just so that things are understood and people are clear and comfortable going in and know what to expect.
John?
One of the interesting things is if you work or you deal with an American-based company, one of the most difficult things to deal with, though, and I found, Sheila, is that employment at will in the U.S., they just assume that it exists up here. Why do I need to put that in the contract? We can do as we please, so don't worry about that in your letter. That's what when you say, let's introduce employment contract, well, why bother? It's employment at will. Well, no, it's not. And that's one of the biggest challenges, so that you find with American companies. And that's where there is not, from what I understand from talking to people who have an American-based firm, that there's a large rise in the use of them there because, you know, they haven't changed from that practice in the United States.
Janice, did you want, or Jeff, did you want to add anything to it?
Well, I think what John was just saying is right, although at the higher executive levels in the U.S., everybody has contracts and they provide for really quite generous termination provisions. And I must say, sometimes I do act for employees, and it really is a lot of fun when you're dealing with an American company and they think they can get away with employment at will, and you can stick them for a big settlement or a big judgment because of it.
We always enjoy uneducated American clients. I hope I haven't offended anybody. Janice?
I actually have as clients a number of American corporations that set up business here. So my job is to educate the uneducated. And certainly one of the hurdles is we don't have
Great
employment
unwashed.
at will here. And for those people, when you think about it from a legal cultural perspective, if you're used to employment at will, what do you mean we have to give people reasonable notice? And for us, that's a really easy concept to understand, but for them it's like what, like it's a real stretch. The best you may be able to do is to get them to agree to an employment contract that either adopts the statutory standard or the statutory standard plus. That's as far as they may be able to go, because the standards are so very different.
Second question, and this is the toughest question. I mean, it's great for lawyers to say all the time, well, you know, we want to argue just cause. Where's all your warning letters? What's happened? You know, give me all the corrective discipline measures and all those wonderful things. But what's it like to actually do it on the ground and actually have to give a senior executive a discipline letter? And what's the reaction and what are the issues? Sheila, John?
I would say from my experience, it's very limited to actually give discipline letters to senior execs. There's more discussion and perhaps, you know, encouraging the individual that maybe it's time to look for something else. And ultimately, one reality is it becomes so difficult to perhaps demonstrate cause that's why it's good also to have in the employment agreement what the termination package would be, because oftentimes you're not able to really establish a thorough case unless there's been something very forthright, like fraud or something of that nature. So basically, it's difficult to give senior executives letters of discipline, and you're really moving to the encouragement, the coaching, and potentially coming to an agreement about exiting and what that would look like.
John?
I guess one of the biggest challenges, and it goes towards the concept of the Wallace cases, where you have senior executives who have, many times individuals are brought into a company, they're hired for their knowledge and skills, and invariably, and I guess Sheila, we talked about this before, they're fired for attitude and behavior. And attitude and behavior is the most difficult thing to document, obviously, and but it is probably the most disruptive force in the workforce at the senior level, attitude and behavior, where maybe there's a difference in opinion on strategic direction, a difference in opinion on strategy. And so what ends up happening is that, and also attitude and behavior go to create, I think I heard someone talk earlier about that employers may have an attitude or a reason behind the termination other than just what was laid out, and that some employers, you know, heaven forbid that an employer might be vindictive, but there's something else there which becomes personal. I know, Barry, you never see that in your practice, but what ends up happening is when you get into that, and if it's a difference in attitude, you will see two executives square off against each other, potentially. And I guess the question comes up that then if the lines are drawn, as soon as you issue that type of letter, then you've drawn, and legal counsel gets involved on both sides. And I guess the question then comes, you invariably will hear, why do we have to pay them any money? I don't want to pay them any money. I've got cause. You know, and that, you know, invariably, and I guess I get the phone call. The phone call comes into you, Barry, and we proceed from there.
I think if I can jump in, I think it's really important to, for client and counsel to, before you do this, before you send the letter, identify what the objective is. If the objective is, you know, we want to build a case for cause, we want to minimize our damages. If it's an issue of performance, which invariably it is performance attitude, the fact of the matter is where the case law is at now, you know, you can do progressive discipline on a very sophisticated level. You can send 7 letters, you know, clearly identifying the behavior and the protocol and the whole thing, and still not get to cause. So if that's what your objective is, I think your obligation as counsel is to tell your client, look, it's unlikely you will be able to meet that objective. And I think you also have to ask your client, in your heart, you know, do you see a future with this employee? And if the answer is no, and in my experience, invariably that's what the answer is, then I think call it a day. Deal with the person properly, fairly, figure out what reasonable notice is, and don't waste time, operational energy, emotional energy in protracting a relationship that clearly is not is clearly not working out. If your objective is to truly correct the behavior, then I think you have to think again very carefully about how you're going to do that, because a lot of managers cannot manage to do that. A lot of managers cannot manage to deliver a message that the behavior needs to be different without the employee hearing the message feeling quite threatened and defensive. It just doesn't seem to be a widely held talent of managers. So you need to think about who's going to deliver the message, how is it going to be delivered, and what kind of supporting mechanisms are there.
Jeff?
I think as well, you have, Janice, you have to make a decision right at the outset of what you want to do with this, the discipline procedure, because in my experience, I guess I disagree with Janice. I think you can set up a series of letters or communications with the employee that will satisfy the court that you had just cause for terminating the employee if the employee doesn't meet the standards set and he was given appropriate warning of what the consequence would be of not meeting those standards. However, to write that kind of letter, my experience with my clients and my experience in my own firm where I'm responsible for a lot of associates, is that if you write that kind of letter, you get A, an unhappy camper, or B, someone who's not going to be with you anymore because they're going to leave because they don't like being treated in that fashion. And if it's a strong market like it is right now, you can't tell any associate lawyer to improve their performance at all because they're going to be walking across the street.
You guys sure out that out there?
And so it's the decision has to be made from the outset. Do you want to write the letters that give you just cause and the consequences that will entail, or do you want to work with the employee and have them stay with the firm? And
John?
If I could, because it's an opportunity now to address now a group of legal counsel, and as Sheila and I are practitioners, if there's one important thing for us, particularly if you're dealing with more junior level managers or HR practitioners, one of the most important things is when you get into the case and you have a situation like this, and let's say there's a lot of bravado on the side of the company, we've got our case, really you have an obligation really to let them know what the dangers are of the path, particularly in this discipline of going, the path you're taking and what the implications are. Because that individual, particularly an HR practitioner, will say, okay, the lawyer says no problem, we got cause, let's go. They go to the senior executive, say, here's what the lawyer says. And our legal counsel says no problem. A decision is made based on that, okay? And then inevitably, if it goes bad later, they'll say, hey, who gave us this advice? Who gave us this advice? And then, it's right, Barry, they're pointing the fingers and, they're looking for the lamb somewhere out there to sacrifice. So it's important, and it's also important to encourage the HR practitioner to understand, listen, there's two sides, you need to know what your options are, as opposed to getting them caught up in the bravado of, this is a real macho thing, let's make sure we punish this person. Let's let them know what the company really thinks here. Is to make them understand the implication.
In the interest of time, let's look at the next question. Through the last day and a half, we've been hearing about Wallace, and it's sort of filters into almost all the discussion. But when you're looking at the Wallace scenario from an HR perspective, and what impact does that have on your thinking and the processing and the conduct of the termination and the challenges? Sheila?
I know John feels quite strongly about this, so I'll let him start off.
Well, unfortunately, whenever we have a termination, they say, what firm's representing you? We go, Kuretzky, Vassos. Oh, wasn't he involved in Wallace? Oh, yeah, we have a Wallace case. And you go, no, we don't have Wallace here. What are you talking about? I think one of the most important things is the education of the managers and the executives as to some of the principles behind Wallace. Actually, I really enjoyed Marilee's presentation today of moving beyond Wallace and kind of defining what it means, because a lot of lawyers will come and in their letters will say, well, it's Wallace. And if the executive gets the letter, they'll say, well, what's Wallace mean? And I think the important thing is that it's important to contain that so that the executive understands as you move forward in other termination cases exactly when you don't have cause, how you should conduct yourself. And I think that's one of the most important things, is you will always get into the situation where they say, what do you mean I don't have cause? And that, I think, is one of the hardest questions to deal with, is what do you mean I don't have cause? We just lost $50,000 on him.
that's one of the things I spend a lot of time doing with managers is explaining you may have a good reason, but that's not the same as having cause. And trying to make the, we may have a really good reason to make this decision, but we don't have the facts to support it. And
also the concept, and you learn very quickly, if you're ever involved in a termination situation that goes really bad, you learn all the stuff that is involved in Wallace. And the important thing to understand as you're moving forward is making sure the managers understand what a really effective termination looks like, right from where it's conducted, all those kinds of conditions, and before, during, and after. And that you have, it's really important that if you're providing counsel, that the HR people understand, based on some of the things that have come out from these cases, what a good termination looks like, so that you don't get embroiled in that later, like what happens, the concept of outplacement and references and containing all that information, I think is probably, if you're going to take them down the road and they insist that we still have to have this termination for cause, well, let's make sure that this termination for cause is conducted in an appropriate manner.
We can talk about this particular topic, I think, for a long time, but I want to get the last question in because I think it's an important one, and we were talking about it again in the last day and a half in some of the speakers in terms of how to effectively manage the discretionary bonus during the employment relationship and after termination. So not only the discretionary bonus, but introducing profit sharing. How do you say to an employee, we'd like this restrictive covenant signed, and you'll get some shares? Like, how do you actually do it on the ground is the question. Janice, perhaps?
Well, I think the problem with all of these things is what you call it isn't necessarily what it is at law. Maybe somebody else wants to tackle shares, but in terms of the discretionary bonus, I guess the point that I want to make is, even if you, as the employer, explain to the employee, look, this is a discretionary bonus, but prior to the termination, there's a history of the bonus being paid, every year, so that it becomes integral. You can call it discretionary all you like. It's not a discretionary bonus in accordance with the principles of employment law. You're going to have to pay it out in all likelihood over the notice period. So, to some degree, simply limiting your communication with the employee, it's discretionary, isn't going to protect you as an employer. What's going to protect you is if it's not paid out on a regular basis.
I think from an employer's point of view, obviously the worst case scenario is after termination, the court says you paid this so regularly it became an integral part of compensation, so it's the average bonus over the last 3 years. That's what you're going to get during the notice period. In my experience, the only way to prevent that happening is if the facts of how you paid the bonuses are such that they were truly paid on a discretionary basis. They were only paid when the company met a certain profit level or the employee met a certain performance level. And what often happens is the employer doesn't have the time to properly document what its policies are, or they don't take the time. And clearly, if you can document what your policies are and what the standards are of when the bonuses will be paid and not be paid, and if you follow that procedure, then on termination, during the notice period, the employee is only going to receive that bonus that he otherwise would have received if the particular profit projections or whatever of the company are met.
Can I just add one comment
Please.
to what Jeff was saying? Even if this is properly discretionary bonus, there is an obligation on employers to assess the discretionary bonus objectively in good faith, which means, and it's interesting to link these things thematically. What we do in the Walls cases is we put our minds consciously to how a termination meeting is conducted and the aftermath. In bonus cases, what that standard means is you as the employer or employer's counsel have to put your mind to, okay, what are the factors in the discretion? How does it apply to this particular person's performance, and what number do we get? It doesn't mean, discretionary bonus doesn't mean here's the pot and I'm deciding willy-nilly who gets what based on, who I played squash with last week. That would be an abuse of good faith in my view.
John or Sheila?
It's been my experience that employees, no matter how much you describe it as a discretionary bonus structured to them, the first time they receive payment, it's a permanent arrangement in their minds. And the first time they don't receive payment, there's a discussion about how unfair that is. The one way that I think is a very good way to protect limit and really treat it truly to some degree, not so much as discretionary, but to put some limits on it relative to termination of employment, is to make sure the employment contract specifically defines and not just says termination, but defines what that means. So, you know, on the first day of resignation or at the beginning notice is provided, that kind of thing. And that's been a good way through my experience.
John?
Yeah, one of the things that I guess, Barry, we've learned through experience is that also it's important that, and I emphasize this with our staff and with our managers, if you have, as we said, a situation where you're moving towards some form of discipline or bringing to an end the relationship with the manager, one of the most difficult things that happens is that somehow these bonus payments seem to slide in through direct deposit, and things happen automatically, and you end up somehow at the either in litigation, or you end up in a situation and all of a sudden, you know, say, hey, well, I got my bonus. What do you mean we have a poor performer here? And what's really important is that if we have a situation where you're moving down the road towards either correcting behavior or ending a relationship with an individual, you got to make sure you're on top of, particularly with sales executives, these incentive and bonus payments. And I mean, there's a whole issue relative to you know, incentives based on sales, raw sales, but any kind of bonus payment, because the important thing is that you don't want to end up in a situation later where legal counsel comes in to help defend you, and you say, oh, did I forget to tell you they got their bonus 3 months ago? And invariably you have to, you know, then you have to backtrack and you have to deal with that. So it's important that managers understand, if you're moving down this road, let's maybe talk to legal counsel about what we do about this pending bonus that's coming.
I want to thank everybody on the panel, and we'll take our lunch break now. And if everybody could really be back at 1:15, because the afternoon is really packed, and we want to leave sufficient time for the judges panel. Thanks, everyone, and especially thanks to the panel.